And you can take it into account because the statute says so, right? Is the government's view that you can take it into account because this statute requires the court to refer to 3553A, and 3553A says sentencing disparities have to be taken into account?
That's exactly right. The other point I would make, Justice Gorsuch, and it's baked into your question, is that this is an inference. It is an inference from congressional silence. And all of the government's arguments ultimately rest on trying to find implied limitations from congressional silence. The government wants to infer, and it's not just an implied limitation, it wants to infer a categorical bar against consideration of this fact, the fact of sentencing disparity. And it wants to infer not just a categorical bar on that factor, but a categorical bar on that factor ever entering into the equation, even though in combination with other factors or alone, even though Congress didn't do that when it identified a specific factor, rehabilitation, as one that's off limits. That is a lot of meaning and content to read into congressional silence. There are at least 5 statutory rules of construction here that counsel against exactly that inferred limitation. The first is the most basic one, that this court does not lightly assume that Congress omitted from statutes text that it meant to apply. That's Justice Scalia's opinion in JAMA. The second one is the rule that where Congress puts a specific limitation in a particular provision, you don't infer another one. The third is the rule from Kimbrough. We're dealing with a sentencing statute. Congress has said, this court has said Congress knows how to direct sentencing practices in express terms and has shown that it has done so. The fourth is the Concepcion principle. You start with the premise that Congress meant district courts to have the broadest possible discretion unless the Constitution or Congress explicitly limits it. It hasn't done so here. And then finally you add on top of that, because you have an express delegation to an agency or here to the Commission, Justice Thomas, your opinion in Little Sisters of the Poor made clear that where there is that kind of clear and express delegation, you rewrite the statute, you don't apply it if you start inferring limitations on that discretion that Congress did not apply. I will just make one more point about the scope of the Commission's discretion, because, Justice Kavanaugh, I think you got that exactly right in the first argument today. This case is much simpler because Congress gave the Commission the responsibility to describe what should be considered extraordinary and compelling factors. The Commission has done that. So the question in this case is very simple and straightforward, and the question is just, did the Commission's policy statement B6, is that a valid exercise of expressly delegated authority?
When you